So welcome, good afternoon. We are here to discuss the Secure Act 2.0 in a very conversational format, providing with a general understanding of what our legislators meant to do in passing the act and what the practical outcome has and will be for you as a plan sponsor and for your employees. I am your host, Carmela Elko, Managing Director at Trinity Advisors Group. And I'm joined here by my esteemed panelists, Michael McCabe, President at Trinity Advisors Group, and David Hall, Chief Marketing Officer at Hall Benefits Law Group. So just to give you some perspective, there are 92 provisions in the Secure Act 2.0. So if you found it challenging to keep track of what applies to your plan and when, you're not alone. So we're here to give you a general understanding of some of the most impactful provisions, focusing on when they become effective, because there's all different kind of effective dates, and what you should be thinking about from a planning and strategic planning perspective. So we're also conducting a webinar especially tailored for nonprofit organizations on Thursday. So please feel free to tune in if it's of interest. And we will be recording our WebEx series so you may refer back to them if you feel the need or want to share it with a colleague. So in addition, you may download some helpful materials during this webinar. You can see them under the handout section, or we can provide them to you afterwards. So please feel free to ask questions, which we'll answer time permitting at the end. So without further ado, let's begin. So first question here, Michael and David, can you briefly discuss the idea of intent versus impact for the audience and explain why we took this direction with our conversation?
Sure, Carmela, I'll jump in on this one. Just by way of background, my name is David. I'm the Chief Marketing Officer here at HBL. We're a boutique ERISA law firm. We're headquartered in Atlanta, Georgia, and we are serving plan sponsors and service providers in 39 different states. Our team works closely with plan sponsors and service providers to help make sense of the pitfalls and the opportunities afforded by Secure Act 2.0. And so we're having lots of conversations these days. The fact is you can get a provision by provision breakdown of the act online and read detailed descriptions of all 92 provisions. But at the end of the day, we're here to talk about what I think really matters, which is the impact to the plan sponsor. So the Secure Act 2.0 was signed into law on December 29th of 2022, and Congress had four stated goals. The four stated goals of the act are to expand employee access to retirement plans, to increase Americans' retirement savings, to preserve Americans' income, and then one that might be arguable, streamline formerly complicated retirement plan rules for both participants and plan sponsors, and perhaps add a few more wrinkles and complications while we're at it, right? But those are the four stated intentions of the act. So let's step away from the intent for a moment, because regardless of the intent, plan sponsors are left with lots to think about. You have questions around elective versus mandatory changes, effective timing of provisions, the perception of plan participants of provisions that you as a plan sponsor may opt in or out of, right? And so you need to be thinking about those things. So as we think about the intent of the act, we think we're going to jump into some examples of how we should be critically thinking about optional provisions and mandatory provisions. Michael, it'd probably be helpful for our audience if you could speak to the way that we've decided to frame the conversation, the three areas of impact that we'll be looking at, and then after you've done that, we can jump into some specific examples.
Great, absolutely. Thank you, David, and thank you, Carmela. So before I get into that, our firm, Trinity Advisors Group, we are a 401k, 403b defined benefit retirement plan consulting firm who works exclusively in this space and supports not only plan sponsors, but participants as well. So David, you just mentioned the intent of Secure Act 2.0. Let's talk briefly about the actual impact. Right now, we have no idea what it's really going to be. like all government regulations and rules, this is not easy. It's not clean, simple, or clear. If you feel confused, you're not alone. It's going to feel like drinking water from a fire hose. So as these different provisions inside the Act become more clear, we'll be able to share what the actual intent and impact of is with each of them, and how it will impact you directly as a plan sponsor.
And I would like to add to that, Michael. Actually, you know, we had a general session last week, and we got some very specific logistical questions on some of the topics, you know, that we'll be covering again today. And we just don't have all the answers. So I think, you know, an idea would be to come revisit, you know, these specific provisions once we have clarity, and kind of dig into some of the very, you know, the logistics and specifics. So moving to the first provision that we're going to be talking about, let's start with Roth. So Michael, we know that there are a number of provisions in the Act that have to do with this concept of pre-tax versus post-tax dollars. Can you remind the audience a little bit about what Roth contributions are and what the impact of to either plan sponsor or plan participant as it relates to the Secure Act 2.0?
Absolutely. Now, I'm sure as plan sponsors, you recognize that pre-tax dollars go in before participant pays taxes, they grow, and then at retirement, when that participant starts to pull that money out to fund their actual retirement, they have to pay taxes at their current income tax rate. With Roth, the money goes in after taxes, and as that money grows, when the participant pulls the money out at retirement, they will not have to pay taxes when they pull the money out, so they get tax-free growth. Well, currently, any company employer contribution that goes into the plan is put into pre-tax. Now, effective 2023, this year, with Section 604, employers will have the option to put the participant's match in a Roth provision. So remember, this is effective 2023, but it's also optional for the plan sponsor to decide whether or not to do that. Now, this sounds great, but the reality is that there's some wrinkles that you're going to have to clear, or hurdles you're going to have to clear along the way, things that you have to make a decision about. First one is that all contributions must be 100% vested when contributed. So if you have intentionally put in a vesting schedule in your plan, this will circumvent that schedule. Second thing is you're going to have to work with your TPA if you use one, and your record keeper to implement this change. And then the last one is you're going to need to communicate with your participants about the change and why you're going to do it. David, can you speak a little bit more on this about the impact?
Sure, and I think you make a great point about the TPA, Michael. You know, many of us as plan sponsors, and I'm a plan sponsor, right? HBL has a retirement plan. We work with a TPA, and we need to make sure that our TPA is capable of implementing this change and has the proper tools in place themselves to operate your plan with this particular provision in place if you choose to make this a part of your plan. So I would first just say that some impacts to your plan based on the Secure Act 2.0 may have nothing to do with your putting the provision in it. It may be more to do with making sure you're working with the right service providers. So that would be my first observation. But speaking, you know, relative to intent and impact, on one level, you know, I think we have a tendency, we're cynical about anything having to do with taxes. And so, you know, some people may be looking at this as a revenue play, right, on the part of the government, since the IRS will collect those tax dollars on the Roth matching contribution virtually as soon as they're made. But I do think we need to remember the stated intent is to increase savings of plan participants and to expand access to retirement plans. And I do think this provision does that on a couple of levels. Not knowing what tax rates are going to be in the future, I suspect they're probably going to go up. That would be my prediction. there's a lot of upside to a post-tax contribution to a retirement plan, right? Because regardless of future tax rates, the growth will not be taxed, nor will the corpus ever be taxed again, right? And so for plan sponsors, this doesn't seem to be much of a downside to this particular provision, other than the aforementioned, making sure that the provision is working properly, that your plan is operating according to the plan document, et cetera. All the things an ERISA attorney would tell you are important, but there's not a lot of downside for plan sponsors. Giving participants more options instead of less options with their money typically is an attraction tool when we talk about attracting employees or retaining employees. So taking advantage of this early on, and remember this provision is available to you immediately. If you're a company that has a lot of competitors in the marketplace, putting a provision like this in place sooner than later may give you a competitive advantage over other folks offering similar benefits packages.
Great, thank you, David. And a lot of plans offer, Roth employee contributions, so it is just expanding. And I'm sure if your plan offers them, you have people that are really find that, a valuable benefit.
Right.
So let's shift gears and take a look at an optional provision under the umbrella of participant savings. This has gotten a lot of attention. The student loan provision permits an employer to make a matching contribution with respect to a qualified student loan payment. Michael, how does this mechanism work, and what should plan sponsors be thinking about when considering this, offering this provision?
Yeah, Carmel, this is one of my favorite provisions inside the Act. We all know young employees who are burdened with student debt and can't unfortunately participate inside an employer-sponsored plan because any money they have left over, instead of going into the plan, is being used to pay off student debt. I have 3 of those at home, actually. So I think the ability to allow employers to use the match to offset a participant's debt payment is a really, really good thing. So Section 110 of the Act, which begins in 2024, so next year, when a participant makes a student loan payment, the plan sponsor employer has the option to match that payment as if it were a payment into a qualified retirement plan. So in the vein of expanding access and increasing savings, essentially employees who might not have participated in a retirement plan in the past will be able to do so, but also pay down their student loans. So I'll let David speak to the plan sponsor considerations, but I think it's clear for a number of reasons. This may not be ideal for all plan sponsors, but for some it will be. What are your thoughts, David?
Great point. And one of the things I would tell my students when I was a teacher many years ago is let's put on our thinking caps, right? So on the face of it, this looks like a no-brainer, right? Oh, we're helping people pay off their student loans. Fantastic. Well, let's think about who our people are, right? Every workforce is different. Every optional provision, and this is an optional provision, a plan sponsor adopts, is going to incur cost in some form or fashion, whether it's, we previously spoke of having to do the work of amending your plan and then making sure that your TPA is making sure that it's operating properly according to the plan document. There is a cost to putting optional provisions in your plan. So in this case, the plan would need to be amended, and then we would have to actually implement this match, and there's a mechanism by which your TPA would need to do that. So let's think about both sides of the coin. There's these employers are on a spectrum, right? And so let's think of a tech firm. And everybody they're hiring is straight out of school. Maybe they're engineering graduates, and they're competing for young talent. These candidates are saddled with significant student debt, and so this could be a really attractive option for that employer. But on the other side of the coin, right, on the other side of the spectrum entirely, you've got a blue-collar manufacturer, right? They've got 500 employees. They don't have a ton of turnover. they're really leaning on that blue collar workforce. Unless there is a very specific reason that a typical member of your workforce, as this employer would have student loan debt, adopting this provision would be really more of a waste of time than a benefit to your employees. And quite frankly, those resources, those time and resources could go into maybe enacting another provision that's more appropriate for your workforce. So all that I'm saying goes to the idea that just because Secure Act 2.0 makes something possible to implement in your plan, it is not a good enough reason to move forward. So while I do agree with Michael, I think this is a great provision. It speaks directly to the intent. We want to make sure you're thinking critically about the why of the decisions you make around your 401k plan. And to also, through a webinar like this, give you access to professionals who are having these conversations offline, who've thought through some of these concepts on your behalf and are ready to get with you and take that conversation to the next level.
Thanks, David. So we haven't even touched on changes to emergency withdrawals, required minimum distribution, or catch-up limits. So if you have any questions about any one of those or another provision we did not use as an example today, please contact one of us directly, as we'd love to have that conversation with you. And again, I think as a great follow-up to this webinar series is to kind of really, once we have clarity on some of these provisions, to kind of do a deep dive on, for example, student loan contribution. So I think that's a great topic. Moving on, I'd like to close, however, with an interesting provision of the Act that, we can tie directly to Congress's stated intent, which is called a sidecar savings account, which is where participants, it's linked to their individual accounts. And Michael, David, what are your thoughts on this kind of provision and how it could be received by employees and plan sponsors?
Great. So Michael, you did a great job explaining the student loan provision. I'll go ahead and jump in here and see what I can do about the emergency savings provision. This is section 127. This provision is effective in 2024, so for plans starting in 2024, and it provides employers the option to offer eligible non-highly compensated employees only emergency savings accounts. And this would be part of the process of the participants' 401k plan enrollment. And employees' contributions, if they opt into this, they can opt out, excuse me, will then be held in a limited number of principal protected investments in a separate account, a savings account. These deferrals are treated as Roth after-tax deferrals, and those employee deferrals must cease once the account balance meets or exceeds $2,500. So essentially, you've got a little bucket you're going to fill up before the employee contributions start going into their main account. Employees will have 100% tax-free basis in those after-tax contributions, and any of those investment earnings will be then distributed tax-free. So while an employer may design the plan to auto-enroll eligible employees, those employees do have the opportunity to opt out. And so just kind of tying some of these things back to the intentions of the Act, let's think about expanding employee access to retirement plans. If you feel like your employees may not be participating in a plan due to their perceived inability to save for emergencies and for retirement, this may increase their likelihood to enroll and to take advantage of a plan. In terms of increasing Americans' retirement savings, you're not really going to increase their retirement savings per se, but at the separation of service, the provision does state that the employee may take the account as cash, or they can roll it into a Roth defined contribution plan or an IRA, right? And then preserving Americans' income by helping minimize the extent to which individuals have to take on debt to address an emergency. I think this provision, really speaks well and answers the intent of the Act well. Michael, you might have some additional thoughts.
Absolutely, David. This section, section 127, is actually kind of interesting. When we first looked at it, we thought it was very big brother, big sister, if you will, of an act, right? The ability to put participants into a savings vehicle. But the more we looked into it, we know that the employers have the option of implementing it, and the employees can opt out on an individual basis. We also know that while individuals can save on their own, far too many fail to do so. So according to a recent report from the Federal Reserve, almost half of Americans would struggle to cover a $400 emergency expense. So many are forced to tap into their retirement savings. Another recent study found that in the past year, almost 60% of retirement account participants who lack any type of emergency saving tapped into their long-term retirement savings, compared to only about 9% who had at least a month of emergency savings on hand. So what we know is that separating emergency saving from one's retirement savings account will provide most participants a better understanding that one account is used for short-term emergency needs and the other is for long-term retirement savings.
Now, one thing actually too, I wanted to comment on are participant loans, right? So an idea for the audience, if you're considering the sidecar option, you might want to rework your loan provisions or your loan program, right? If you're allowing some additional flexibility. So it just goes to the overall general concept here that we're trying to share with you, is that one, adding these optional provisions obviously is very individual to your participants and to your plan, but also you may want to take this opportunity to review your plan and how the different provisions interact, right? And kind of identify the goals of what you're trying to accomplish. If you're trying to improve plan, the overall plan metrics, if you will. So anyway, that's my commentary.
Well, and I think that's great commentary. And if I could just piggyback on that a little bit, something we spoke about in last week's webinar that was focused not as a general session as we are today, but on small business, was participant education, right? And so if you're thinking about implementing a provision like this one, make sure you're educating your workforce so that they get the benefit that Michael described, right? Think about the impact to these workers when, what is the stat that almost 60% of participants who didn't have any retirement savings tapped into their long-term retirement savings? That is very unfortunate when you think about the opportunity cost of those investments being taken out and used for emergencies. And then on top of that, you have the federal government, which frowns upon those types of things, and the participant can actually be taxed at a much higher rate if they don't pay back the loan. And so, this is one of those things where, again, it took me some time to wrap my mind around the fact that, there's really no harm here, if you give your participants this option, but you do have to educate them, right? And make sure they know if they're opting out, what they're opting out of, and if they're opting in, what they're opting into. So again, the overall point I'm trying to make is simply the importance of plan participant education.
Thanks, David. So we had a few questions from our session last week, and I will pose one to our panel here for a quick answer, since we are, coming to a close. So first, from Rebecca, a CPA in Texas, had asked us, how will employees elect Roth match, and how is that reported from a plan perspective? Do we treat it like an in-plan Roth conversion and issue a 1099 that comes in a pre-tax form from employer and then converted to Roth, which is taxable to the employee? So I don't know, Michael and David, if you want to kind of address that particular question.
I'll take that to start. So this provision, it goes into effect this year, 2023. but it's also important to recognize that it is optional. So if you are going to allow to have employer contributions go in at the Roth provision, you're going to have to amend your plan. So you're going to have to work with your TPA and or record keeper to get that set up. So how it's going to show up on a participant's account statement or online when they go to look at it, it's just going to be another line item. It would say employee contribution, employee Roth contribution, employer match, employer Roth match. So it's just going to show up as another line item or another bucket. And the second part of your question, Carmel, related to Roth conversion and issue a 1099. This is not a Roth conversion, so an employee will not get a 1099.
Okay, thank you.
Yeah, that's good, Michael. So just to be briefly piggyback, I know we're going to give some logistics here and sign off shortly, but I would simply say it's critical, regardless of the provision that you're putting in place, that the plan is operating according to the plan document, right? You can't have somebody representing an ERISA law firm who's not reminding everybody 10 times that your plan and your plan document have to match up, right? So with a provision such as Roth employer match, the plan document should describe exactly what is happening with the employee and employer contributions, and then the plan operation must match exactly what the plan document says. That's how you do a real CYA, and then you memorialize your decision making, get it on ERISA letterhead, and you're good to go.
Do you know where we can get some ERISA letterhead, David?
I think there's some in my office somewhere.
Thank you. So as a wrap up, or to summarize, some basic steps you should take. So you want to, we've mentioned this throughout here, is to evaluate your employee population today and in the future, right? If you kind of have a vision of what your employee demographic is going to look like, kind of build for the future using some of these building blocks, right, in the Secure Act 2.0. Identify which elective provisions would resonate the most with your employees and to aid in retention and attraction, right? That's been a big challenge. Obviously, identify the elective versus mandatory provisions and take the necessary steps, right? We mainly talked about elective today, but there are some mandatory ones that we have covered in previous sessions. Again, I'm happy to kind of go over some of those with you in the future. So use this as an opportunity, again, to evaluate your plan design, make sure that the changes kind of coalesce and kind of accomplish the goals that you're trying to meet for your employees. And then there's always cost, right? You want to evaluate the cost of adding, for example, the student loan, where you're going to have more participants participating, and that might add, cost to your match, for example. And then finally, we look at this as sort of a starting point of our conversation with you, right? We look at it as, well, we call it the four-legged stool, right? Having a strong ERISA attorney or counsel, having a strong advisor, a strong record keeper, and obviously a dedicated plan sponsor. So having that team in place will help guide you through a lot of these changes and help you select the best ones to implement on behalf of your employees.
Absolutely.
So I know, Michael, David, if you have any final thoughts.
I think I'll jump in, David. Carmela, you hit it right on the head. Surrounding yourself with a strong team who has experience and expertise and who can help educate you as to the Secure Act is the best thing that you can possibly do.
Good. Absolutely. Yeah. And then just from a logistics, perspective here, reminders, you'll get an email from us. It'll have some future webinar links in it. It'll have a link to both last week's general session and small business session, as well as to this session and to the nonprofit session that we're going to do this Thursday. If you are a nonprofit, I would encourage you to please sign up for the nonprofit session that we're going to do Thursday, same time, same place. Wherever you signed up for this webinar, please sign up for the nonprofit. And on behalf of Carmela and Michael, we'd just like to say thank you. Thank you for being here, and we hope to see you soon.
Thank you.